Good morning. I hope you've all had a nice weekend. My name is Stephanie Breen, and I'm the school policy staff attorney at SALI. And as you all know, the final Title IX regulations finally came out on April 19th. And I'm sure everyone has a lot of questions about what they mean for educational institutions and for survivors moving forward. So we've put together a pretty high-level review for you today to go over some of the biggest changes. So this morning, I want to start out by giving a quick overview of the history of Title IX and how it is to where we got to where we are today. And then I'll go over some of the most important changes that have been made to the regulations. The updates that I have for you today, like I said, are going to be at a very high level, so they're not going to be an exhaustive breakdown of the new regulations. And that's just because there are over 1,500 pages to the new regulations. And so we at SALI, as well as many other amazing advocacy organizations, we're working very hard to get through all of the new material as quickly as we can. And once we're able to do so, we do plan to break that information down and give additional trainings on the concrete ways that schools need to change their policies in order to come into compliance with the new regulations. Today, I will also talk about the time frame for educational institutions to update their Title IX policies, and I'll explain what schools need to be doing now to remain compliant. So as a refresher, Title IX was enacted as part of the Education Amendments of 1972. It's a federal civil rights law that prohibits discrimination on the basis of sex, and it applies to both K through 12 schools as well as to higher education. The language of Title IX of the statute states that schools are not allowed to discriminate on the basis of sex in the context of an educational program or activity, and that Title IX applies to any school that receives federal financial assistance, unless that school is exercising a religious waiver. If a school has a religious mission, that means that they may be able to apply for a waiver stating that Title IX should not apply. And then while Title IX is often thought of as the law that requires equal treatment of students in the sports setting, which is true, it also very importantly governs university responses to sexual harassment. And as I'm sure everyone is aware, federal guidance surrounding Title IX has really been in flux over the last couple of years. So I want to give a brief overview of the history of the federal guidance. So prior to 2011, there was very limited enforcement of Title IX, and federal guidance was often overlooked. And then under the Obama administration, the Department of Education issued guidance in 2011 and in 2014 in the form of a Dear Colleague letter and a questions and answers document. The Dear Colleague letter clarified that sexual harassment of students, which includes acts of sexual violence, is a form of sex discrimination that's prohibited by Title IX. And then the questions and answers document provided additional guidance concerning schools' obligations to address sexual violence as a form of sexual harassment. And both documents served to strengthen student survivors' rights. And then in 2017, under the Trump administration, Betsy DeVos, who was then the Secretary of Education, rescinded that 2011 and 2014 guidance and proposed new regulations in 2018 through the formal rulemaking process. So that process allowed for the public to make comments on the proposed rules. Despite receiving considerable backlash from students, universities, and advocacy organizations, among others, DeVos, her final rule was published in May of 2020, and then it went into effect in August of 2020. These are the rules that we have been operating under since 2020, and they are the rules that we are still operating under at this point in time. So then when President Biden took office, one of his stated priorities was to restore and strengthen Title IX protections for survivors. And this is because, as we know, the 2020 regulations did roll back a lot of the protections that student survivors had. On March 8th, 2021, President Biden issued Executive Order 14021, stating that it is the policy of his administration that all students should be guaranteed an educational environment free from discrimination on the basis of sex, including sexual harassment, sexual violence, and discrimination on the basis of sexual orientation and gender identity. He ordered the Secretary of Education to review the existing regulations to determine if they were inconsistent with that policy and to consider suspending, revising, or rescinding them. Then in June 2021, there was a 5-day nationwide virtual public hearing that was held to give students, educators, and other members of the public the opportunity to express their views regarding Title IX. During and after that hearing, the Office of Civil Rights received over 30,000 written comments as well. And then after much anticipation, the Biden administration finally released its proposed rule on July 12th, 2022. And that was also through the formal rulemaking process that enabled the public to again submit comments. The Department of Ed called this response historic. They received more than 240,000 comments on the proposed rule, which was almost double what they had received on the Trump rule. And in large part because of the huge response that they received, as we know, the final rule, the release of that rule was subject to numerous delays. So we expected it initially in May of 2023, and then it was pushed into the fall and then delayed again without a firm date provided. And then the final rule was finally released last month on April 19th. And although the regulations have been released, they are not actually in effect yet. So the new regulations do not go into effect until August 1st of 2024. So what that means is that educational institutions have until that date to update their Title IX policies and to train their staff on the new requirements. To be clear, in order to maintain compliance with Title IX right now, schools must continue to employ the policies that comply with the 2020 regulations. So in November, I gave a training that went into detail regarding schools' obligations under the 2020 regulations and how schools can best support student survivors under those regulations. The link to that training can be found on our website, and we will also send it out to you at the end of this training. I expect that there are probably a lot of questions about the new regulations, and I do want to just say I might not be able to answer all of them today. As I said, we're working diligently to read through all of the pages of the regulations and to distill them down. And we will be giving more trainings. So please be on the lookout for announcements about additional trainings that will go more into depth and be more comprehensive regarding what institutions need to be doing to come into compliance. And I anticipate that those should be ready hopefully sometime in June. And you should have received a link to a form where you can submit anonymous questions that we will strive to answer in our next training. So please feel free today to ask me any questions still in the chat. I'll do my best to answer them at the end. But if I don't know yet, then I will definitely make sure to incorporate those into the next training. So now I want to go over the high-level takeaways of the new regulations and highlight what the key differences are between the new 2024 regulations and the 2020 regulations that we've been operating under. So first, the new regulations clarify and expand the scope of what discrimination on the basis of sex includes. And they clarify that discrimination on the basis of sex does not have to actually be sexual in nature. So under the 2024 regulations, sex discrimination includes discrimination based on sex stereotypes, based on sex characteristics, based on pregnancy or related conditions, sexual orientation, and gender identity. Sex characteristics are physical traits of a person, including their genitalia and other sexual and reproductive body parts. Sexual orientation regards who a person is attracted to or drawn to romantically, emotionally, or sexually. Gender identity regards a person's personal and internal sense of self and their experience of gender. So that's whether they identify as male, female, non-binary, transgender, gender neutral, agender, or any other gender expression that I have not mentioned. And then pregnancy protections include protection against discrimination based on pregnancy or pregnancy-related conditions. So this will include things such as lactation or related conditions and recovery. Schools will be required to provide reasonable accommodations to pregnant and lactating students, and that includes reasonable break time for things such as lactation and to provide clean and private spaces for students and employees. And then schools must also now provide materials to students who are pregnant or lactating regarding their rights and the school's obligations. So if a school receives information that a student is pregnant, then they are then obligated to provide that student materials about their rights and the school's obligations to uphold those rights. The new regulations also expand the definition of what constitutes sexual harassment. So hostile environmental sexual harassment is now defined to include unwelcome conduct determined by a reasonable person to be subjectively and objectively offensive and so severe or pervasive that it limits or denies a person's ability to participate in or benefit from the education program or activity. Under the 2020 regulations, a school did not have to investigate conduct unless it was both severe and pervasive. So this change to or instead of and is extremely important, and it means that more conduct is going to qualify as sexual harassment under Title IX. So for example, under the 2020 regulations, a series of microaggressions that occurred over a long period of time, they might have been considered pervasive, but not sufficiently severe to be covered by Title IX. But now that conduct would qualify. And then under the old regulations, a single, very shocking and lewd comment might not have been considered pervasive, even though it would be very severe and would not have qualified under Title IX, whereas now that comment would be captured. Under the 2020 regulations, sexual misconduct must have occurred within the United States in order to fall under Title IX. So even if the conduct occurred during a school-sponsored trip or in a study abroad dorm room that the school owned, the conduct would not have been covered. Additionally, under the old regs, the conduct must have occurred under an education program or activity. And this meant that the conduct must have occurred in a location or event owned or controlled by the school. So this would include buildings that were owned or controlled by any officially recognized student organization. But now under the 2024 regulations, if conduct occurs outside of the US or at a location or event that is not owned or controlled by the school, but it then creates a hostile environment for the student when they return to the school, then the school does have the obligation to address the hostile environment that is created. So for example, if two students are off campus on winter break and one is alleged to have sexually assaulted the other, and when they return to campus, this causes a hostile environment, then the school will be obligated to respond to that allegation. So this will likely increase the number of complaints and investigations that schools are seeing. Another change to the regulations involves the training requirements for faculty and staff. So under the new regulations, it's clear that, Under the new regulations, it's clear that schools will be required to train all of their employees on the scope of conduct that constitutes sex discrimination. So employees will not be required to evaluate whether the conduct reported or the information that they learned meets every aspect of the definition of sex discrimination. They don't have to make that determination themselves, but rather they need to respond to conduct or information they learn that could reasonably meet that definition. The regulations also clarify that if an employee directly witnesses conduct that reasonably could constitute sex discrimination, then they will be considered to have information about conduct that reasonably could constitute discrimination. And these training requirements are going to vary based on the individual's role. So in the next training that we provide, we will give more concrete information about what those specific requirements are and how they're going to vary. Another change to the regulations is an expanded investigation mandate. So the new regulations clarify a school's obligation to take action to address sex discrimination. Under the 2020 regulations, schools were only required to investigate conduct when a student filed a formal Title IX complaint with the Title IX coordinator. But under the new regulations, schools will be required to take action when they have knowledge of conduct that reasonably may constitute sex discrimination, regardless of whether a formal complaint is made. So this means that schools will need to increase their responsiveness to knowledge of potential sex discrimination. And this also means that oral reports of discrimination will be just as valid as written reports. And then related to the prior slide, the new regulations also expand the mandated reporting requirements. So the 2020 regulations eliminated the prior responsible employee standard, and a school was only considered to have knowledge of discrimination when a formal complaint was made to the Title IX coordinator. But now the responsible employee standard has been restored, which requires employees who are not designated as confidential employees to notify the Title IX coordinator of any information that they learn that reasonably may constitute sex discrimination. So it's going to be very important for schools to be clear in their policies and to inform their students about which employees are mandated reporters and which employees are considered confidential, so that a student who is not ready to file a complaint does not inadvertently trigger the investigation process by confiding in, let's say, a favorite professor or a coach. Another change is with regards to live hearings. The 2020 regulations had implemented a requirement that colleges and universities conduct a live hearing. Prior to 2020, live hearings were not required. The new regulations return to that prior standard, and they say that schools may conduct live hearings if they choose, but they also have the flexibility to utilize an alternative process that they may feel will better resolve a complaint. So for example, schools could return to a single investigator model, which is where one person both investigates the case and adjudicates the case, whereas under the 2020 regulations, a different person was required to conduct the investigation versus oversee the adjudication. Another change to the adjudication process regards cross-examination. The 2020 regulations had implemented a requirement that complainants and respondents submit to live cross-examinations during the adjudication phase. The new regulations have eliminated that requirement. Schools are again permitted to have cross-examination as part of their proceedings if they would like, but they are not required to do so. And an alternative to cross-examination that schools may now choose is to have the complainant and the respondent draft questions for each other that are then asked during an interview with the investigator. So the students would not be directly questioning each other. but rather the questions would be passed to that investigator who would meet one-on-one with each student and ask the questions. Another change regards the burden of proof. Under the new regulations, schools are required to use the preponderance of the evidence standard in all grievance procedures for sexual harassment, unless they use the clear and convincing standard in all other comparable proceedings at the school. So what this means is that institutions will not be allowed to subject students that are going through the Title IX process to a higher evidentiary standard than for other similar types of conduct. The standard has to be uniform across the board. Previously, schools were allowed to pick and choose which standard applied to different types of complaints, but that will no longer be allowed. And then the new regulations also clarify and reinforce that schools must prohibit retaliation, including peer retaliation, and must respond to retaliation using the same procedures as for other forms of sex discrimination. Retaliation was also prohibited under the 2020 regulations as well, but the new regulations clarify that peer retaliation is included, and they clarify how schools must respond. Additionally, investigations and adjudications, as before, are still going to be required to be prompt and unbiased, and schools will still be required to provide supportive measures to students. And I'll go into further detail about what those measures need to look like in our next training. And I know that was very quick, but that does conclude my high-level review of what we see as being the biggest and most critical changes to the Title IX regulations. And if you have any questions, please feel free to put them in the chat and I will do my best to answer them. And if I can't answer them now, then I will be sure to address them in our next training. I'm hoping to have that training out no later than mid-June, and that presentation will give a much more comprehensive overview of what will be required under the new regulations and how institutions will need to adjust their policies to come into compliance. So more concretely, what things need to change in policies to be in compliance. And again, schools have until August 1st before they need to finalize their new policies. So there's definitely some time to get that taken care of. And I'd also just like to throw out a quick reminder to everyone to keep state law in mind and recognize that there may be some places where state law will impose additional requirements. So in our next presentation, we will be sure to address any of those places with regards to Maryland law. And then if anyone has any specific questions about their own policies, about training their staff, or how to implement these new regulations in their policies, we provide technical assistance, and I would be more than happy to assist you with any of those questions.
Great, thank you. Thank you for that wonderful presentation. I would like to direct everyone's attention to the chat. I posted the anonymous evaluation form. We greatly appreciate all feedback as we're constantly striving to improve. Additionally, you'll see that I posted the the Google form questions for you to submit, the Google form for you to submit your questions to us to inform the next Title IX training session. Both of these forms are anonymous, so feel free to put your comments or questions. Again, we greatly appreciate you being here. You'll receive a copy of today's recording, as well as the links that were posted in today's chat. And I'll be including a copy of the PowerPoint slides, so that way you can contact Stephanie if you have additional questions. We'll stay on for a couple of minutes if anyone has any questions that they would like to be answered. Thank you all for coming.